We're on a roll, Chris. This is the second episode of what's now going to be called the Reasonable Measures podcast. Thank you for coming up with this brilliant name last week. You saw sort of our relationship in action. I ask you a question, I sit back, and you come up with an answer. So nice work on that. Thank you.
Thanks, Tim. You have the easy job.
uh, so, a few things to talk about today, and to kind of reiterate what we sort of thought would be our kind of format going forward. A handful of talking points about what's going on in the market, topical things, and then we'll jump into a case. Today, we're going to talk about Vanda Pharmaceuticals and their case against the U.S. government. Before we get to that, handful of things to go through. Number one, you're in the Bay Area at a conference, one of our favorite conference producers, the folks at Kisico. How's that going?
Oh, it's going great. It's a 3-day conference. The first day was all about trade secrets the whole day. And then days 2 and 3 are about IP leadership and coming up with good ways of managing companies' intellectual property in general. So not only trade secrets, but patents, trademarks, and copyrights. So it's a great crowd and lots of good conversation. There are a lot of hot topics going on, especially this week. So there's a lot to talk about.
Awesome. I saw a handful of our friends, Jim Pooley's there, saw Ben Herbert. So it looked like a good group of people. So, okay, cool. Well, the big news that came out, I think day one of the conference, been a couple days now, is the FTC ruling to ban non-compete agreements. And so I think this is such big news that we need to dedicate probably a half hour to this. So maybe that'll be episode 3. And the Wall Street Journal headline this morning in the editorial, Lena Khan's latest rule instantly invalidates 30 million contracts without congressional authority. Pretty big deal in our world. And so I know it's something that we've been talking about since the FTC put out the proposal. A lot of folks in our community have been talking about this and thinking about this. And I know you are actively drafting a piece that we'll put up on the website here soon. But I think this idea of, I've largely sort of thought about non-compete agreements as sort of the lazy person's way of managing trade secrets, right? You control the person, you don't really control the data per se. And I think, what California has proven to all of us is that life goes on without non-compete agreements because they've been at minimum hard to enforce there for a long time. And so anyway, love to hear your quick feedback on FTC. And I don't want to get too deep on this because I do think it deserves a longer discussion.
Yeah, definitely. I mean, we can dedicate episode 3 to the FTC. And it was funny, the ruling or the rule came out at 11 a.m. local time, the first day of the conference. So starting around 10:45, everyone's checking their laptops and checking their watches. It was very much like the ball dropping on New Year's Eve. And no one was really focused on what we were supposed to talk about. But it is a real significant ruling from the FTC that invariably is going to be litigated like crazy because it is a very real substantive change to non-competes. And like you mentioned, California, it hasn't been difficult to enforce. It's been completely unenforceable. So California has, for a very long time, taken the position that non-competes are just not constitutional in the state. So they're just not available. And yet somehow, miraculously, California has been wildly successful in launching startups, having great technology companies, and Silicon Valley is the hotbed of innovation even now. So people's concern that getting rid of non-competes will just grind the innovation machine to a halt doesn't make sense. Look at California, where I am today. So yeah, it's going to be real interesting, but it's actually a great thing for protecting trade secrets directly, because non-competes, like you mentioned, controls the flow of people. So your people can't leave your company and join a competitor. And indirectly, it helps protect trade secrets because if the person can't move, they can't bring trade secrets with them. But it's very much indirect. Like that's not the main intention. So if you can't protect it indirectly, you'll have to protect directly. And all of the laws and procedures around trade secrets are only going to become more critical. And we're definitely going to see an increase in the amount of trade secret litigation because non-competes, if this rule actually goes through and is enforced, will be unavailable to trade secret owners. So this is big, big news.
All right. So, all right, we'll start prepping for episode 3. So let's table this
Yep.
discussion for now and jump into Vanda. So, Vanda Pharmaceuticals Incorporated is a plaintiff versus the United States, the defendant. And so, what we're going to look at here today is a decision that came down January 18th, 2024. So, pretty new. And so a little bit about the company. So Vanda is a $250 million market cap, so small cap pharma company. According to this filing, they sort of have a business model of rescuing failed therapeutics, sort of breathing new life into something that has failed along the way. And this particular ruling is around 2 motions. And so the U.S. is asking to dismiss 2 things. So, or there's 2 things that are at play here, Chris. So, Fifth Amendment takings claim and a breach of an implied contract. So, before this case, and I think what's just incredibly fun for me, and it's weird to even hear myself say that, is that I love reading these things and seeing things I've never seen before. So I have no idea what a takings claim is. I know what the Fifth Amendment is, I think in principle, but this is a super interesting trade secret case because essentially what Vanda's saying is that, hey, these folks at the FDA disclosed our confidential information to competitors, and that's not good. So I have tons of questions for you, but I would love, with that little bit of setup, to sort of hear your thoughts on the case.
Sure, Tim. And this one is interesting to me because it is so different. If you read enough trade secret cases, after a while, they tend to fall into familiar patterns or familiar buckets where an employee typically will leave, they'll take information with them to a competitor, and then the competitor uses that information to develop products more quickly or compete with that first company. And you see that same pattern over and over and over again. This Vanda case is fascinating because it doesn't fall into that pattern.
Yeah.
So Vanda produces brand name drugs and they go to the FDA to get marketing approval for various conditions, which is great. And part of the deal with the FDA is I'm going to submit a lot of information to you in getting my drug approved. And the FDA is not supposed to share confidential information from the applicant company with others. And it's even in 18 USC 1905, where if the government receives trade secrets in the course of their official duties, they're not supposed to share it. So what happened here is interesting because there is no competitor. So it's not like the FDA released a drug and started competing. They just shared some information with generic applicants. So a bunch of companies were trying to get approval for a generic equivalent of 2 Vanda drugs.
Right.
And in the process of negotiating with the FDA shared some specifications for the drugs with that generic company. And Vanda is upset, but a typical trade secret assertion doesn't really work because the fact pattern is so different. So Vanda's lawyers are super creative. Like I love whoever came up with this idea of saying it's a taking by the government. And you mentioned, Tim, that you're not familiar with takings. You actually are. You just didn't realize it yet. So this usually happens regarding real estate, where if the government wants to build a new highway or build a new train tracks or you know, a new federal building, and they need to take people's land, like if there's a neighborhood there that needs to be demolished to make room for a federal courthouse, the government can't just take it. They have to fairly compensate you for the value of whatever property you've taken. So, what Vanda is saying here very creatively is that by sharing that information, it was actually taking something of value away from Vanda. So again, it's super creative lawyering, which I always enjoy reading about. Yeah, I like to think I'm creative, but this one is super creative. It's impressive.
So there was a couple of things where they talked about starting to talk about some of the specifics that were disclosed, and I thought, as both chemistry nerds, we it sort of fit into our, and I'm looking for it here in the in the complaint.
So it
Or
had
the
to do with the dissolution rate. So how quickly
There you
these
go.
drugs dissolve once they're swallowed or ingested. And it's further complicated or further interesting that Vanda originally applied with certain dissolution specifications, like parameters. And the FDA didn't like that. And the FDA actually suggested, hey, if you change it to a different specification, we will allow your drugs. We'll grant you the marketing rights. And Vanda, of course, said, yes, that's great. But then years later, the generic companies applied, and also FDA didn't like their dissolution specifications, but then suggested the exact same ones that Vanda agreed to. So it's, again, a further complicated or further interesting situation where the FDA actually suggested it. They weren't asked, they provided that willingly. And then, of course, the generic said yes, and then they got approval as well. And then Vanda got obviously really upset about it.
Yeah,
So,
so I see here the claimed confidential information regarding the manufacturer's process for detecting and controlling impurities
mhm,
in the drug's active ingredient,
yep.
as well as, quote, the methods through which it controls the size of the
Hmm.
crystals of the product
Hmm.
itself. So, anyway, comes back to good old chemistry, which is pretty cool. Um, so the decision ended up being kind of split. Yeah. So may walk us through what the court decided here.
Sure. So this case is still ongoing. It's still actively being litigated. And this is really a very first step. So, what always happens is the plaintiff files a complaint saying defendant did various bad things. And invariably, the defendant will immediately file a motion to dismiss, saying there's some defect or some problem with the plaintiff's complaint, and they should just end the litigation right here. So there were really three things that the defendant, the government or the FDA in this case, were saying. So, first they said the federal takings isn't appropriate. Second one had to do with breach of contract. And the third one was actually a statute of limitation argument for the very oldest of the generic companies. So, what the court said is the first thing, the federal takings can proceed to trial or to further in the litigation, but the other two were dismissed. So it's kind of a mixed ruling, but the litigation will proceed. And fortunately for us in the trade secret business, the most interesting argument will be carried forward, and we'll see how that goes. Again, it's very creative, and whether win or lose, it'll be interesting to see how the court handles a takings clause with this fact pattern.
Okay, so the breach of an implied contract. So basically, is what the courts are saying here is, um, there may be some other statute or like regulatory requirement that the FDA keep this stuff confidential, but there's no implied contract here. Is that a sort of a correct read?
Yeah, I mean, they were saying that yes, the process of applying for drug approval was somehow a contract that got breached, and the court basically said, no, that's not the right way to think about this. You know, breach of contract would typically be between two companies where I agree to do something for you and you pay me or give me something back, and then someone doesn't do what they're supposed to. Uh, Here, they said this fact pattern isn't really appropriate for a breach of contract claim, so the motion to dismiss was granted for that. So Vanda will not be able to carry that cause of action forward.
All right, Chris. So I think to tie this off, sounds like this case is very much in motion. We'll probably be hearing a lot more about it. Um, in terms of biotech companies, life science companies, anybody that's interacting with the FDA or needing FDA approval, does this case shine a light or suggest anything in terms of how those kind of companies should be thinking about their trade secrets and thinking about their interactions with the FDA?
I think it does. And it's a bit of a wild fact pattern. It kind of reminds me of a law school exam that's just super complicated or super interesting, depending on how you look at it. But it does show that trade secrets are a super valuable and important part of the drug approval process. And everyone thinks about the Orange Book and which patents cover the active pharmaceutical, but this case highlights that trade secrets can be just as important. And the brand name drug company needs to protect their trade secrets from ultimately getting in the hands of their generic competition. So it really does show that it's patents and trade secrets, not patents or trade secrets. So I love this case. It's going to be fun to watch.
Okay, so now I have one more question because I, I was thinking this as I was reading was so let's say again we're in hypothetical land here for a minute, but a government official has this information, they know it's proprietary. Let's assume that, and they share it with someone, right? So they have misappropriated the information. Are they criminally liable?
I don't know. That's something we'd have to think about. I mean, they're definitely violating 18 USC 1905. Like that was written specifically for your hypothetical.
Okay.
I'm not sure it rises to criminality. I mean, it would have to be pretty egregious or pretty serious. Like they left the FDA and started their own drug company with all this information. Uh, but yeah, that's
Or,
it's a wild question. We'll have to see. I
or
mean,
they were
right now, this is all civil litigation. This hasn't been brought to the DOJ or FBI, at least not yet.
so that would be like a DOJ case against the FDA. Do those even
Yeah,
exist? Anybody?
it's. I mean, that's totally uncharted waters for me,
Okay.
and the chance of that happening is so slim. I mean, at this conference in San Jose, we did talk about when the DOJ gets involved, and there were even a couple of agents from the FBI talking about trade secret litigation, which was pretty wild to think about. Uh, but it's normally after a company or a non-U.S. entity. Uh, it's hard to imagine the FBI going after the FDA. That's a real stretch.
Anyway, here, I guess, as I said in my LinkedIn post, welcome to the future.
Mhm.
Great second episode, Chris. Thank you. And we will dive into FTC and non compete ban here next week. Thanks, man. Have a
Awesome.
good trip. All
See you
right.
next
See ya.
time.
A little bit more about us. Tangibly is a platform to help companies identify and protect their trade secrets. It's an end-to-end solution and includes our proprietary AI that was designed to analyze patents and predict underlying trade secrets. Tangibly is used by companies large and small, as well as by law firms. Our investors include Madrona, as well as DLA Piper and Wilson Sonsini. Thanks for listening, and we'll see you next time.